let me get back to me. Can you explain the abbreviations? TOPIAD, these are things, so I'm assuming, I realize that for some of you, this may be the first time you really talked to me. A lot of this builds off of previous work or videos that I've distributed over the last couple of weeks. Very, very quickly, TOPIAD is just a dumb acronym for Take a Practice Exam a Day. Most students don't do this. They wait until the very end of the semester, usually after Thanksgiving, their first semester, and they take practice exams then. My method emphasizes even starting over the summer, although I realize at this point it's a lot of you are on the verge of starting law school. And but you start from the beginning, and you take practice exams. Really hardcore people will take them, like 5 days a week. But the key is that you at least practice several times a week, because there is a learning curve to get up. So I'm going to take a little more time to explain this, and I'll kind of get to the next thing. You are admitted within certain LSAT and GPA bands, which means that your peers are exactly your peers. They're just as smart as you, and they're just as hardworking. So the question is, how do you do better than they do? You can't. It's hard to outwork them. It's hard to just simply do the same things they're doing, but better. There has to be some advantage, and I think one of the key ones is to start to take practice exams earlier and regularly, because it is a muscle that you develop over time, and most students only begin to, let's say, lift weights at the very end of the year. The rule of general, so a lot of this is stuff, if you go to my YouTube channel, Larry Lala, in YouTube, you'll find a lot of these. But I talk about it there. The RGA, as I thought I just said, is the rule of general application. This is not a term that other professors use in class. This is not like a technical term. This is, to me, a very law school specific term that I've invented, because I don't think the terminology that you use helps very much. When you kind of pick apart a case, you discuss the holding, which is the resolution of the specific problem before the judge in that case. But if you read something like a commercial outline like Gilbert's or Emanuel's, there's a more generalized form of that. There's a reason that the common law works this way. It doesn't work off a code. Each case contributes a little bit to the law, and there's a forward-looking aspect to it. So it doesn't mean that it's completely general, but it's coming up with a more general formulation of the holding of a particular case so that you can use it for new fact situations that you've never encountered, which is exactly what you get on a final exam. All right. Nicole's question, so let me come back to that. Is this what you did to get good grades, or did you learn the hard way? Also, what specific things have past top students of yours told them that worked for them? So I didn't, in a way, I didn't have to learn the hard way. What happened to me was I was headed off to law school. Nicole, I don't know if you want to unmute or turn your video on. But this is what happened to me. I was heading off to law school. I was going to go to Spain for a couple of weeks with friends, because I'd never really, I think I'd been one other time in some, on a school trip that it happened to be paid for through some student organization. And before I went, a friend of mine who just graduated from Harvard Law pulled me aside and said, "I'm going to tell you all about law school." And I was kind of arrogant. I'm like, I totally don't know. I mean, I'm a smart guy. I don't need help with it. And he's like, "You need help with law school. Come meet me for drinks at this one place." in Reno, the Peppermill Fireside Chat Lounge, where they have fake fire. Anyway, so you can even look up this guy. His name's Eric Johnson. He teaches at University of North or South Dakota. I can't remember which now, but he's a law professor. But he gave me a lot of the foundation for what I set out to you. Some of these things I've developed on my own, but one of the key things is he said never brief cases. So this is the advice that I got and that I took, and that really helped me. And I'll be more specific about how helpful it was. But he said, don't brief cases. Use the commercial outline to pre-study the law before you even get there. Take this outline. He gave me his Convisor mini review and study it. So I did that. I had a good time with my friends, but we traveled a lot by bus and train. And I would just kind of read these things when we were in transit, like I would read a contracts or torts outline. And then he said, focus from the beginning on the exam. Go to the exam cabinet. This was, it wasn't pre-internet, but a lot of exams weren't put online. And he said, go look at your professor's exams and see what kind of questions they ask, and then begin to think about that from the beginning of the year. I did not, I did outline relatively early. I did not take practice exams super early. And nevertheless, my first semester was all A's and a B plus in torts, which I'm still upset about. So I kind of had it handed to me on a plate, and then I just kept doing that. My friend who gave me this advice, he said he found it out the hard way. He was that he got better grades later on in law school, but he didn't know what the game was about at the very beginning. Now, a lot of what I've developed when I started kind of tutoring students privately, like a lot of people wanted to start in the summer and they wanted me to work through, I don't know, substantive law lessons. And I said, I'm willing to do that, but I think the best use of your time is to pre-study the law and then to start taking practice exams. And those students who did that, who really were hardcore about that from the beginning, either starting to take practice exams over the summer or earlier in the fall and let me give them feedback, that kind of student got straight A's. And so some of those are in my testimonials, but those are very real results following kind of this system. Nicole's other question is, what specific things have top past students of yours told that worked for them? You can see a lot of them in, I'm trying to think of variations of what I did. People generally follow this. One guy who just wrote me, and I think I just put this in one of the most recent emails, is this guy who's number 2 in his class at Vanderbilt, which is a top 20 law school. And, he said he didn't brief cases, he didn't reread cases, he read the commercial outlines, and he didn't do tapiad, but he tried to do hypos weekly, and then a lot more at the end. And he worked closely with another student to kind of look at each other's exams. So there are different ways of doing this, but I think this is directionally the right approach to do well in law school.
Thank you.
Sure thing. Jennifer B asks, are there copies of your previous recordings available? Again, I can point you to YouTube, Larry Law. I have more materials behind my paywall in my premium course, but you can get plenty of stuff from there. Just type in Larry Law with spaces in YouTube and you'll find me, or you can do youtube.com/Larry Law. That should also work. Punez says, does Kit Cools have practice exams with answer keys? Yes. I mean, my general approach is I don't. So, what you'll sometimes find out there in the world are past exams and um, either a model answer or a professor's uh, comment on an exam. Um, I try to do something different so you can kind of triangulate these things, and I'm still with some of the exams building them out. But what I try to do with each hypo that I offer is give you an actual checklist first to work off of, so that it's part of the picture. It's not everything. If you missed issues, the checklist will help you. If you got every issue right, that doesn't mean that you're necessarily doing well yet, because you're self-grading and you don't know how your style is or how well you're actually writing. So, or you can fool yourself about what issues you got and what issues you thought you got in working that out. So, I then also offer for a lot of the hypos, or for most of the hypos, student answers, the ones that I've deemed over the years to be kind of the best answers that I've seen, as well as my direct feedback on them. I've also kind of put out answers that weren't the best, but I thought were illustrative of common mistakes, and commentary on that. Like bubble, you'd actually have the text of the exam, and then, Microsoft Word comment bubbles, identifying things that I liked and things that I didn't like. As to some of the hypos, and this is what I have to build out the most, is I actually walk through video to say, given that I was the author of a lot of these hypos, and I'm going to do this as well with certain professors' exams that are available publicly, what I was thinking when I wrote it, and some comments. You can actually watch me talk through and mark up a student's exam.
Larry,
So,
when you're talking about these hypos, are you talking about the ones that are in the vault in Kit Cools?
no, these are the main ones. The vault at this point mainly has, because they were students' real exams, markups, my markups of their exams
In the vault.
in the vault. But I'm
Okay.
going to, I mean, so that's why it's a limited set of things. I didn't want to just give you the exam. It's stuff that I've actually handled and had something to say about. I
Great.
I would like to add checklists and videos for those as well. But those are still forthcoming. Okay. So I'm just going to keep working through these. From Jay Roselle, I have two questions. Do you think reading an E&E hornbook and case summary book for a class is useful? I heard that reading a case summary book, then reading E&E, then a hornbook, then the case is useful to understand the black letter law, or is just having a commercial outline sufficient? So I've commented on this question before. I'm sorry, I don't know why the light keeps going in and out. I'm trying to, maybe I'll try and stand at the distance so that it doesn't fade in and out. You don't have unlimited time. So, if you had tons of time, fine, you could read a ton of this. Most students don't. Given that you have limited time, I mean, we're talking, it's August already. Reading an E&E and then reading a hornbook and then reading the case, I mean, that's the kind of stuff that you would have had to have started in the spring. I think it's insane, and it's not necessary to get the kind of results that my top students have gotten. They're not, my straight A students are not students who did that. There are two flaws with that approach, in my view. One is that it leans on the crutch of, and maybe it's an unspoken assumption that you have that goes back to your undergrad days, that if I know everything there is to know about these cases, I will do well in law school. that is simply mistaken. It isn't about a law school exam may have a couple of more obscure, like you'll have a new fact pattern, and maybe a couple of things in there will refer to things the professor referred to obscurely. But the problem is, students who can write, who've kind of memorized every single fact detail, they find that issue spotting is a totally different thing than just knowing the facts of different cases. And a lot of the times you'll get an A minus or even B plus just by competently organizing and clearly analyzing really super basic doctrines that you've learned in class that everyone should know that are not obscure. The real game is being able to analyze deeply and well. This is another indirect way of saying this, but I remember seeing an answer rubric once somewhere, and the professor thought that there were maybe 100. I mean, this is not exactly it. That there were maybe 100 different points that you could have got on the exam, and an A exam was like 47. There's more there. There's more detail there than you can handle competently in the short amount of time that you've got. There's a huge premium if you know a lot of the basic law and you can apply it well. You're going to kick plenty of asses that way. Okay, so let me take a step back. There's one E&E that I think is useful and it's the Glennon on civil procedure, because of the subjects, civil procedure is the most law-y. I mean, law is procedure in a way. Or I forget, H.L.A. Hart's the great legal philosopher. He had a way of talking about primary and secondary rules. Primary rules are actual rules of conduct. Like, if you want to use an example, I've got 2 young daughters, and don't punch each other. The secondary rule is, what are the consequences of not following that rule? Civil procedure falls in that second category. It's secondary law. It's the pipes. It's not the actual liquid. But my Civ Pro professor, who was the dean at NYU, said, you decide what poison. I control the pipes, and I'm going to put that poison anywhere I want it to go. I think that's how he said it. I got an A in his class, but I wish I could remember what he said. Given that, I mean, everyone's watched like Law and Order and criminal procedurals or The Wire, so there's a lot of like kind of, the normal subjects will seem more intuitive to you, and so an outline really will suffice. For civil procedure, I get the Glennons and read that. Now, a Horn book I would not get for anything. Those are huge books. They are super detailed. A lot of the times they're really for lawyers to use in practice. And there's just more detail there than you'll ever need. I mean, just all kinds of say torts or different doctrines that you won't encounter in class, and I just don't think it's a good idea. So number 2, your second question is a case summary book necessary, or something like Westlaw Online Summary sufficient? That'll do fine. I mean, if you want to use canned case briefs as well, if that saves you time, knock yourself out. I mean, Quimby, I've seen their stuff. I'm wavering between liking it and not liking it. They offer a lot of case briefs. I tend to think they start the wrong way. I wouldn't write them the way that they do, but they can cut down on your work, so why not? Nicole asks, how do you feel about taking a practice exam, say, for an hour a day? So here's the thing about that. An hour is a lot. I mean, there's what you can do is take segments of exams. You're not going to finish a 3-hour exam a day.
Exactly. So I'm trying to figure out like how to break it down, like how to make it manageable, but work on a little bit like each day.
Yeah, I think a lot of exams that are built to be in class, like 3.5, 4-hour exams, they tend to have 3 or 4 questions. I don't think that many professors are cruel enough to just put a single question on a 4-hour exam. So if they break it up, take one segment a day. And I think that's something that I'd like to do with the vault, so that you can take a full exam if you want to, but you can also go question by question and
Yeah, I was
be
thinking,
able to do an hour a day. Sorry.
I know that's okay. I was thinking about using like the vault first, for the first few months, and then as it got closer to use, my professor's exams or, exams, I guess, from my school.
Yeah, I think that's the right approach. That's
Okay.
absolutely the right approach. You don't want to burn through your professor's actual old exams until the very end. You want to kind of, and I mean, you've heard me talk a lot, so stop me if you want. You want to build up the muscle, and you can do that with issue spotters or exams written by other people. As you get closer to the end, if you want to really kind of struggle for the A, you want to lock yourself as much as you can. So hopefully you've already built that muscle up, but the kind of bodybuilding types that I know, if they're going to bulk up, they don't worry about fat too much. They gain the weight and they gain the muscle, and as they get closer to the competition, then they worry about cutting fat. So if you want to use that analogy, it doesn't matter what you use to bulk up at first, and then but towards the end of the semester, you do want to just focus on your professor's own exams.
Okay.
So, but that's something I'll work on. Cheeto, if that's how I say it, says, do you think your advice is applicable to law schools generally or American law schools? I'm an Australian law student in Sydney. For whatever reason, like my old site, Law School Hacker, picks up a lot of international students. I've had, I'll say this, I've had more Canadian students have had decent success with the kind of methods that I offer. I get questions occasionally, and mainly from law students in English common law countries. So the UK, Australia, an Irish student just asked me a question the other day. I think that it's generally applicable, but it's in the experience of the Canadian students that I've had. But I still think Canada's kind of different from the other, when I get questions from Nigerian students. The shorter answer is, I think so, but I've looked at some Canadian materials. I have to be honest that I haven't looked directly at Australian materials. If this helps, when I was at NYU, consistently the best LLM students were Australian. Like I did an internship at the UN, and my friend who went now teaches law at University of London, and she was like #1 in her LLM class. That just seems to keep happening. So I don't know if there is enough. That's to me an indirect indication that these methods would work the same way, but I don't want to tell you that I've looked at Aussie law stuff when I haven't. I hope that helps. Okay. Shari has the same question, kind of the same answer. Kev says, hello, what strategies work well for reading cases, especially when you have to read multiple cases per day? Kev, I'd advise you to look at my other YouTube videos, and so there are. Let me do this really fast because I feel like I've said this before. Here's what you do to read cases. Number one, buy yourself a commercial outline. Get Emanuel's or Gilbert's. They are usually keyed to the 5 or 6 most common case books that are sold. Okay, so you have a reading passage, and you can kind of look in the key at the beginning and see where in the outline that bit is covered, and then you can kind of pre-read and then read the case. Do not read the cases, a given case, repeatedly to try and understand it on your own. If you want to surprise yourself, then read the case, and then once you've done that, whether you're lost or not, then look at the corresponding part of the outline, the manuals or Gilberts, that describes the case and tells you what it's really about. Because this is knowable stuff, right? You're kind of going through this harder exercise for reasons that I don't quite understand. Because, and I think more out of tradition than anything else, I think professors struggle to articulate why they make students do this, except a survivorship bias. They did this, they were good law students, ergo it must be important to kind of read and reread the cases, whereas I just don't think that it's important. The other thing is to read the cases actively. Don't read to just memorize the facts. Think about what the case means. I have these videos that say don't brief cases. All a case brief is your dissection of a brief in an attempt to understand it, constantly creating work product. If you do that, you will kill your semester. It will prevent you from having time to do the other things, specifically taking practice exams that you really need to do well in law school. And part of this is on me to communicate all of this well. I say this, and then inevitably half the students that I talk to ignore me, and then I get emails. And I got one recently from a student that I posted in my kind of broadcast emails a couple days ago that said that they wish they'd actually followed this advice earlier. So use an outline, read the case actively, and make hypos in your head. Think about what it would take to have made the outcome different, like within the same set of facts. So the Harry Hand case, what would it take to award pain and suffering? What would the nature of the pain and suffering have to be like for Hawkins to have won damages on that? And then what are other facts that are kind of different from this case that that doctrine would apply to? There's a question. I know your strategy is to start practice exams straight from the beginning. How can we do that from week one if we barely know anything yet? Are there practice tests to take based on the order of a typical curriculum? I have two answers to that, and I didn't. One is the course that I have, Kit Cools, is specifically designed to deal with this problem. I start with kind of bite-sized typos, and I give you the law to apply. So it's a little bit artificial. It's a bit like training wheels, in that on a true exam, you won't know in advance. I mean, you have to know. You have to use your judgment to figure out what law applies. But plenty of students have problems with just the analysis part, or somewhat more complicated hypos. I give you some sets of law that you can just read on the spot and apply. Maybe not all of it applies. So there's a little bit of the mystery of full-on issue spotting. The other thing you can do is, whether you buy Kit Cools or not, is to, one, pre-study the law by reading commercial outlines. Now, that can sound daunting, and a manuals or Gilbert's is 300 pages long. The good news is you don't need most of that. There's a capsule summary at the beginning, which is 30 to 50 pages, depending on the topic, and then a super detailed outline after that. You only need to read the capsule summary. For instance, I read something like that, even shorter, before I went to law school. So you could actually do that. You can read a capsule summary on a Saturday. Take all of a Saturday morning. Maybe not do that during the week, and then start to take practice exams. Now that's a little bit harder. So that's why I wanted to build an easier on ramp with KitCools. But those are approaches that you can take. Now, if you follow that fear, but if you take that and you use that as a reason not to take practice exams early, you'll be in the boat that everyone else is. No one else will take practice exams partly because they're not told to do that. But even if they were so inclined, I hear that a lot from students. But I don't know enough law. It's not necessarily sequential. If you take a couple hypos early on, you will understand more deeply than reading an exam than reading a case 20 times what's important about a case for the bottom line. There's other research that I've read recently. I can't remember if this is Daniel Coyle's The Talent Code book, but someone did a study. It's like a reading comprehension test. So this is different. This is not mere reading comprehension. But they took two sets of students. One set of students, they had read a passage 4 times, and then they were kind of asked questions about it. They were tested on it. The second set, I don't know how exactly they did this. They only let them read the passage once, and they tested them on the passage 4 times. Guess which set of students ultimately retained more and actually did better? It was the second group. It's actually being forced to actively engage as opposed to passively read stuff that helped them through that. So even for just the purpose, if your end goal were just to get the law into your head, it's one thing to read, it's another thing to be forced to apply, say, the law of battery. That will stick that law in your head more permanently than anything you would guess, than just reading. Marcus asks, do the hypos from the E&E count as exams as part of TOPIAD? Not really. Not in my mind. I think they sometimes have hypos towards the end, but the kinds of questions that they ask at the end of chapters are not they're not open-ended enough. The hard thing to get practice with is with the open-ended nature of an exam. And so, some of them are kind of multiple choice or sort of fill in the blank, or and so from that perspective, I don't quite love those. But they can be better than nothing. I don't want to poo-poo them. Some students I've had kind of use those as well, but up to you. That is to say, so my bottom line is that I'm kind of indifferent towards using E&Es. I think there are better things you can use, but if it's a choice between that and just reading more, then I'm totally for doing some of the examples in the E&Es.
Interrupt for a second. I'm Marcus.
Hello.
Hi, this is Marcus. I want
to
ask a continuation.
Sure. Go ahead.
So there's the vault, which I have access to. I have the E&Es, and obviously there are public exams that I have from the Berkeley database.
Mm-hmm.
The thing I find is that I've gone through the whole civil procedure E&E, but when it comes to an exam, even if I just, let's say, read the first paragraph of events that happen, there will be multiple kinds of areas or sub-areas of civil procedure that even the E&E doesn't touch upon, and I have no problem going through like basic stuff like personal jurisdiction, but I don't even know what I'm not thinking about at certain times when I finish a certain paragraph. Even let's just say somebody wants to begin the process of suing somebody.
Mm-hmm.
So I guess, how do I use exams more efficiently? Do I re-look back at them after I know more, or?
Well, one thing is, at least during the year, you can try to go to your professor. A lot of them will tell you to pound sand, but you do have teaching assistants, and they often. I mean, I was a teaching assistant twice. Show them your exam. The other thing is, since you're not there yet, I guess send it to me.
Okay.
I'll take. I'm not gonna. I'm not gonna. Unless you want to do like the full tutoring thing, I'm not gonna. But I can at least give it a quick look and give you pretty fast thoughts. That kind of. So what you want to do is you do want to get feedback. I think once you get to school, you can be that. I mean, other students are going to be there yet, but the TA usually is chosen because they did very well in that class, and they've gone. They've gone through the whole process, or at least all the law that your professor is going to apply. So the short answer is just drop me an email, give me an example of this, where you felt lost, and maybe I can quickly help you. In any case, use your TA as a resource.
Right.
Ask them to say, how is this exam? What do you think?
I guess I'm just trying to find that perfect area, because E&Es, I can even tell some of them are just designed to tell me about a new law or some small thing that they want to remind me about. So there's like the really simple stuff, and then the exams kind of like the whole ballet. Is there something that's in between that's not just stuff from your vault?
I think I'm going to steal that phrase. The exam is the whole ballet, right?
Yeah.
It's not just, God, my older kid only took like a couple ballet classes, but she won't stop doing jeté, plié, and this sort of thing. And that's how I tended to feel about E&Es. It's like, show me jeté. And it's like, it's just opening your feet. It's not even.
Yeah, I can read a question. I'm like, you're about to tell me something that you haven't told me yet, so I'm not going to do this question because I don't know what I don't know.
Yeah.
So is there something between the whole thing and the E&E that isn't just your vault? Because I can probably burn through that pretty quickly in a few weeks.
Yeah, I mean, some of the hypos are intermediate.
Okay.
But I mean, send me what you if you did something and you feel that way, send it to me, and I can try to provide a quick comment on it. All right.
Okay, great. Thank you very much.
Jay Roselle says, just to follow up on my previous question, commercial outlines are sufficient except for Civ Pro, which you can do E&E as well. I think that's a good summary. You should have a Civ Pro outline because an E&E is not an outline, but I think it's worth reading the Civ Pro E&E to try to understand Civ Pro better. I think that's the one thing that's worth kind of additional reading. So an emphatic yes. All right. Any other questions? I'm here for you. I'm gonna mute so you can't hear me drinking water. Does anyone have any follow-up questions on the things that were already asked? Or, I mean, happy to answer.
I wanted to ask about what Marcus had referenced, a Berkeley vault.
Yeah, so Berkeley, I don't know if it's just a very Berkeley thing, but they have a pretty extensive exam bank.
Oh, great.
And that's a decent one to use. It's up to the professor whether it's not every professor in every year, but it's a decent amount of stuff. And some of the exams have model answers or professors' commentaries.
But do you think we could, let's say they didn't have a model answer or a commentary, is that something that we could take to a TA to work through?
Yeah, I mean, yeah, and the thing is, like, I'm not going to tell you that the TA is going to say, well, thanks, I'm totally happy to go through this. But you should try.
Or maybe even like swap with a
another student.
classmate and at least get each other's thoughts or something.
Yeah, I think that's right. Show asks if we have other questions. You can email me if you have other questions. And I think I'm gonna tomorrow. I'm gonna send some. Yeah. Send me other questions. That's fine. Anyone else?
I got one more question. How far back can an exam go before I can kind of not stop trusting that the substantive law is the same at this point?
I think it depends on the subject matter. Civ Pro and Con Law change with some frequency. So I'd be a little more careful with those. It's still going to be like 80%, 90% the same. The other classes don't, like torts, contracts, property, crim, those don't change very often. There'll be some kind of new or interesting cases that may be fodder for policy questions for crim, but the rest of them hardly ever change. So you can go farther back with the other subjects. Admin changes admin's kind of in between. The core of it, I don't know that Chevron's kind of there, so but there are new cases every year. But it doesn't seem, at least to me, as radically different every year. I don't even want to say that Con Law or Civ Pro are radically different, but they do change. They require updating.
Would you say Con Law is basically unpreppable given like such a wide range of things that people could talk about and focus on?
It may, okay, so it is a huge and kind of random cluster of different doctrines. In the abstract, I'd say yes, and for the bar exam, it'll be that way. Your professor is not going to focus on everything. They're just not going to get through all of that. So once you get your syllabus, you'll be able to narrow it down.
Okay.
They're not going to try to attack everything. That won't happen.
Because my schedule seems like it's going to be Civ Pro, contracts, and Con Law, which is like the three things that are all weird and unpreppable.
I don't know that they're they're a little harder to prep. I'll agree with that, but the thing that I think the easier thing. Another thing that can make Civ Pro and Con Law hard is I've done this video on elements versus factors, and there seems to be, for instance, with Civ Pro, personal jurisdiction or venue or transfer, and a bunch of the different tests for Con Law, more factors. Meaning that like you have to balance a bunch of stuff, and that I think that can kind of feel less cut and dried and more open-ended. But I don't know. I mean, let me unpack that. Let me ask you, what do you think makes those subjects unpreppable?
Well, it seems that both you and like the Lewis Law School exam writing system have just something special, like a special video or special chapter just dedicated to contracts by itself. And if people are focusing on it, I'm assuming there's something special about it. And I'm kind of halfway through the contracts and I can see how, I guess in that sense, I don't perceive it to be all that different because it's very, very basic standard, right? Some people are going to begin a deal and some people are going to breach something. And then and the concepts kind of, the doctrine, so to speak, happen in a sequential order. So I don't think there's anything weird about it, but I keep seeing people saying that there's something special about it that I should be paying attention to.
I think it can be, so it's a bit different than I think that contracts questions tend to focus on very few conflicts. If you have 3 contracts questions, you're only gonna you might just have 3 different situations to deal with. Crim, the professor that I had, it ended up being the hypos were these crazy 4-page things where a bunch of people got drunk and had a conspiracy, and so they were very kind of, I guess I would call them high transaction volume. You were supposed to go dig up a lot of claims. I think contracts can be more difficult for a lot of students because with a grab bag, it can be kind of difficult to dig up a bunch of claims, but it's kind of episodic, right? It's not, to use this, it's not like kind of modern prestige television where you have to know what happened in the last episode for this episode to be that meaningful. It's crim and torts and even property can be a little more like Friends, where each episode can be standalone, and you're kind of one and done with that issue, and you move on. One and done with that conflict, and you can move on. Whereas contracts, you really have to think through. It has to be more carefully structured, and you can't go off half-cocked. I think you shouldn't do that generally, but what can happen with contracts is you need to spend a little time sitting through and really thinking about what the parties are trying to get. What students tend to do is miss that part of it. They don't. I mean, this is almost kind of the application of legal empathy. Like, what does this person want? Why do they feel screwed? What are they trying to avoid? Because what can happen is that students, they feel nervous and they want to show quickly that they can apply law to this, which is not that far removed from the kind of vomiting, like, look at all the stuff that I know. So I remember, going over contracts exams. There's one that stuck out in my mind where the student just took the grab bag approach and, had someone both trying to enforce a contract and then argue mutual mistake. There may be a variety of arguments available to you, but you have to be careful not to argue things that are at odds with each other. If you argue mutual mistake, I mean, if you're seeking to enforce the contract, you want to, I mean, that assumes that you think that the contract is valid. If you argue mutual mistake as to a material issue, it kind of blows up the whole contract. So I say that because contracts has to be carefully sequenced, and because it's not kind of episodic, I think it's slightly more complicated that way. It doesn't mean that it's not preppable, but it's a different kind of beast than contracts, torts, or property.
Okay, thank you.
Jay Roselle asked, do you think the Convisor mini review, I think is what you're trying to say, Convisor mini review, is enough for the semester, or do you think it would be good to buy the commercial outlines as well? I don't know. I just had the Convisor mini review. The hard thing is that the Convisor mini review is not keyed to anything. It's just kind of there. I mean, it's a bar studying tool. It's not even actually a book that you can buy new on Amazon. It's something that you generally get on like eBay or Amazon Marketplace from someone who took the bar and wants to kind of. You're supposed to return these books for a refund, but if you don't return them, then they kind of sit around, and so people like try to get rid of them, and they often charge $100 or $200 for them for a very new one because they are valuable. I mean, this is good law. If I could have done it again, I would have gotten the commercial outlines, but Convisor mini review was enough for me to graduate magna and order the coif. Not trying to sound cocky about that, but it was good enough for me. But if you have the money, get the individual. I like, in doing work with students and kind of prepping my stuff, I like the manuals. I have a Gilbert's or two as well, but I just the nice thing about his Convisor mini review is the boiled down. It is just capsule outlines. I mean, you get all sorts of other materials from Barbary, but what it is you have these kind of longer treatments, and then as you get close to the end, you're supposed to study off the Convisor mini review. If you just have the Convisor mini review, this is not a problem. Like 90% of the time, it's fine. I think it's nice to A, have something that's key to the casebook, and B, has a deeper outline if you want to look on a particular issue. This is not something you should do generally, but if you're really confused on a particular issue, then you can delve into the deeper outline. But there are other ways of researching that. So it's what you feel like. If you want to save a little money, then get a Convisor mini review. If you don't mind spending a little bit more, and I really don't think, as a general rule, you should be skimping on. I don't understand the approach where people are trying to save a couple $100 instead of trying to maximize their $200,000 investment by buying anything they need. If it's cushions, if it's like aspirin, you really shouldn't spare much expense to do well in law school. I don't know if that's an answer, but anyone else?
Larry, I have a question.
Sure. Hi. Who is this?
My name is Glenn.
Hi. How are you?
I'm doing wonderful, thank you. I have a twofold question. The first one is, why do you prefer emanual outline? And two, when you start your pre-planning program, what's the mode of attack? How would you go about doing it? Do you start your outline? Do you make notes at that point? How would one handle that?
Okay. Let me take them. I don't. So let me take a broader step back. I think I just like, as someone who tutors and does this stuff, I just have a personal preference for manuals. Gilbert's covers substantially the same stuff and is formatted the same way. I don't think there's a big difference. Convisor's different from the other two, but still good enough. Take my preference with a grain of salt, but pick one of those three. I have a preference for those three compared to other materials. Okay?
Okay.
On your second question, can you talk a little more? I guess I don't know context. Meaning, I talk a lot about the different things that you should do at the beginning of the semester. But you said something about what's the plan of attack? So do you want to?
I should tell you what I'm doing.
Okay.
And maybe you could shed some light. I personally tape all of my lectures, and I go back and I redo my notes, and I study from that. But by the time I go back and re-listen to the lecture, I've wasted time where I could be studying. Maybe I'm not retaining. Even when I go and re-listen to the lecture, I'm not retaining. And then I've spent all this time.
So you record the lectures and listen to them again?
Yes, I do. And do notes. I have phenomenal notes. But by the time I do all of that, I've lost so much time with trying to study. So it's not being as effective as I thought it would be. So I need to come up with another plan. So listening to you convey doing the pre-plan with the outline might be a better strategy, but I need to know how to go about doing that appropriately and efficiently.
I think the short answer, so one is to remember the end game of exams. Put that aside for a second. What I would do kind of more concretely is look at your syllabus. So you're in law school already.
Yes.
Look at your syllabus. Figure out where there is equivalent stuff in the outline. Read the outline portions and then read the cases or almost skim them. Now, if you want to take another step or two forward, I would even then take that. So I'm against briefing cases or making extensive notes on cases. You can start to build your outline earlier. Then when you get to class, so this is my thought. You tell me if this is something that you worry about. Part of the problem is with, so I talked a little bit earlier in the call. I used to have these classmates who they would transcribe everything because they thought they had to remember every single fact. Is that part of your motivation in recording and taking like really, really, really extensive notes? Is that
Yes.
is your assumption I have to know everything? If there's some fact that I don't know, I'm not going to do well on exams.
I think I haven't learned what's important and what's not important, so I try to gather everything.
Okay. I think the way to try to get at that, there are a couple of ways. So one is to begin to prepare for class this way. I think you'll have a little more confidence if you've looked at the commercial outline, right? The case doesn't explain itself. The outline tells you kind of what the law is that comes out of the case. And that's the main reason to study it, so that there's not a surprise. That way, by the time you get to class, you're not struggling to understand what the case is about or why it might be important. The professor still has more to say on it, and then there's the whole confusing Socratic method when they do a back and forth with the student. But I don't know how much stock that you should put much stock in that, because the professor's going to have that kind of back and forth, no matter how well or how poorly the student understands the material. When you can, I would also try to get to a point where you can take some manner of practice hypo or exam. I think that will clarify for you what's ultimately important. You will learn how hard it is to apply, how hard it is to kind of write everything down and apply all of that in a meaningful way to an issue spotting exam. You'll also kind of have a better sense of the things that you wish you knew when you take an exam. And it's not going to be every single detail. It's going to be the kind of black letter rules that you get out of a Gilbert's or a manual. So I don't, does that help?
Yes, it does.
Why don't you write me, if you want to do this, why don't you write me and just take a week. Let's make it super concrete. Take a week and do this. I don't know if it's this week or the week after. Pick a week and do exactly this. Check the syllabus, get the outlines, study the parts of the outlines that pertain to the syllabus, do the readings relatively quickly, and then go to class and see if it makes a difference, as opposed to trying to understand the law from class. So, I think that's the big takeaway. I think I would not try to go to class to understand what the law is about or what the case is about. you should use the outlines to arrive with at least a basic understanding of that, and then to sit in class to hear your professor's particular gloss on that.
Okay.
That's just one step, but I think that will help. That should help clarify class for you and make it so that you're not. But you have to commit to it. The problem is, I mean, I'll tell you, I've given advice to other law students. My first two kind of paid tutoring students, like, God, I think 7 years ago now. They were really nice. They were really smart. They were really hardworking. But they kept their old habits. They came to me the second semester, and they just, despite what I told them, most of the semester they did what they did before. Which in their cases was, they would pay for these tutoring sessions, and I would say, did you do these things that I asked you to do? And they would say, no, I was too busy briefing cases. And I'd say, don't do those things. So, and I never really, I didn't feel like I pushed them enough on it. So one thing is I would, let me back up. Do you have any other people to trade notes with or study with?
No, mainly because I'm working a lot of hours. So
Are you in like the night
myself.
division of a law school?
Yes.
Well, I total respect. Like that's definitely tough. I would say don't try to do it alone. If you find another night student who's limited in time, so I don't think recording the lectures, listening to them again, and then kind of supplementing your notes is sustainable. It is literally doubling. I mean, if you're doing that faithfully, that really is doubling the amount of time that you're spending on just listening to the lectures. What may be more profitable, not literally, but grade-wise or understanding-wise, is having someone else to trade notes with and to talk through, not extensively, but for maybe 1 hour a week, any particular things that you didn't understand. If your notes are pretty good the first time, there's really, I mean, it's a situation where you may be making the perfect the enemy of your good. What are you getting the second time around? Are you like kind of altering maybe 10 or 20% of your notes the second time around?
Approximately.
Something
probably
like that.
a little bit more.
Okay. I mean, it's a choice that you'll have to make, but I think I would stop doing that and try to find someone to trade notes with and kind of talk it out with. And to pre-prepare in the method that I've suggested. I mean, you don't have to believe me. It may not feel comfortable to do those things. I can just tell you empirically. I haven't run regressions, but with the students I've worked with, like the ones who could kind of drop the habits that weren't helping them tended to do better. But I think it is hard to kind of reach out to the things that are not comfortable because they're a little bit different.
Right. I think a start will be purchasing one of the commercial outlines. I think that will probably make a difference.
But do you think you can do that though? Try for a week where you don't record and you pre-study the law and you kind of prepare that way and see how you feel. If you hate it, then go back to what you were doing before. But I think this will work. It'll really only work if you really kind of commit to this other way for a set period of time and see if it helps you. Okay?
Okay. Thank you.
Shari asks, could you go over that point again about checking the syllabus and getting outlines to understand the class better? Okay. Shari, are you on? Or is it Sherry or Shari? Do you want to unmute yourself?
Hi, yes, I'm here.
Hey. So do you tell me what you want again? Because I feel like I've just discussed it, but I'm happy to do it again. But also let me know like how long you've kind of gone through my materials or how much you've seen before. Because if you're pretty new, then I'm happy to talk through it. If you had been with me for a while, I thought some of my other materials covered that, but
Oh no, I'm new. What you said to her a while ago was very interesting. I missed. You had said that.
so are you in law school yet, or do you have yet to start it?
You have to start.
Okay. There's a different approach you can take. You can just read the outlines. But once you're in law school, so that's what I would call pre-studying the law. And I have a video on pre-studying and side-studying the law. You can look it up, Larry Lala pre-study, side-study. Try in YouTube and try that. But let me go over this with you. So the pre-studying approach is you just read the entire outline so that you have a basic sense of how like contracts works or torts works. And you only read the 30 to 50 page capsule outline. You don't read the long outline that's in Emanuel's or Gilbert's. Okay? During the school year, the side studying involves this kind of several step process. You've got a reading assignment, right? Your professor's going to give you a syllabus. So you look at what that's meant to cover. You want to know what topics it's covering. Emanuel, so if you're using a book, what I mean by Emanuel's or Gilbert's are keyed to the major case books is, let's say they'll talk, there's a section in Emanuel's on Gilbert's. The key will tell you what pages in a given case book Battery covers. What are the specific pages in the case book that cover the same cases that some pages in the Emanuel's covers? If you're not keyed, you can still try to more or less figure it out, because the syllabus will usually say like the topic is battery or negligence or comparative versus some other kind of fault.
Okay.
So you just check the reading, you see what the topic is, and then you read about that topic in the outline so that you understand it. And then you go back and you read the cases. And you read them once, and you don't linger on them, and you don't reread them 5 times. Because there's nothing magic from them. If there's something that's really hard, use your judgment a little bit. But if you pre-study the law, I don't think you should need to spend so much time fussing over the cases themselves. I still think it's important to read them, but what some people do is they just spend tons of time with the cases when I think there are other things you need to be spending your time doing. Okay?
Okay. Thanks.
So is that
yes,
clear enough?
Perfect. Thank
Okay. Anyone else? Okay. I think I'm going to end the recording there.